We're glad to have you back. You're still watching News 90 on Arise News with me, India Mugo. Now, we have Frank Tietie, a lawyer, Arise News analyst, to help us understand where the law stands. By the way, welcome to the program.
My pleasure.
I'm sure you listened to my discussion
with Daniel.
I did. I discussed with another lawyer, and I said, I can't understand this. A high court in Benue gives a judgment.
You mean the Federal High Court?
Yeah, Federal High Court.
It gives an order.
Yeah. And then another one in Abuja. Yeah. I believe they're the same jurisdiction.
Yes, they're of equal, what we call coordinate jurisdiction.
So what happens now?
All right, but you first of all need to look at the subject matter.
Yes.
The subject matter has to do with the relocation of the Benue State Local Government Election Tribunal to Abuja. Who has that responsibility? That statutory and administrative responsibility. It rests with the Chief Judge of Benue State. There is no doubt about that. So first, it's an administrative decision that was informed by, the reasonable perception of, grave insecurity in Makurdi, in Benue State, that it could not, host the tribunal. And that's reasonable, and that's fair enough. And then directed that the tribunal be moved to Abuja for the security of the judges. In fact, I had a report that, there was actually some form of mayhem when the tribunal attempted to sit. There were protests, and there were really attacks, and there were also talks and all that. So no reasonable administrative, leader like the chief judge that is in charge of the judiciary, whose responsibility is to see to the management of the tribunal, would not take a decision. And his decision was that go to a safe venue, and it's not really anything new. We've seen very, very many state tribunals, especially governorship or House of Representatives and House of Assembly tribunals being moved to Abuja because there's a sense of security here. And then we should also actually strive to allow the judiciary to be independent and impartial and not make unnecessary imputations when decisions are made on the face of it. However, one struggles to understand why, parties are now very interested to the point of obtaining court orders. To reversing an administrative decision of the CJ. That's the reason why we had the Federal High Court in Makurdi, ordering that the tribunal be taken back to Makurdi.
Yes.
Now, we have a problem, and the problem is that in Nigeria, an order of court must be obeyed. However wrong it may appear to anybody, even to the authorities. Because that's the provision of the Constitution under Section 287. All authorities and persons must obey any court order whatsoever, even the order of the lowest court in this country, whether it's the Alkali court
or
a
counter
or
by superior court.
Yes, in this case, you see, what I'm not privileged to understand or to see is whether they are the same parties or they are the same issues that were brought before the court, another high court in Abuja.
It's the same party.
However, in that case, I have not verified that because I haven't had the opportunity to do so. So I'll be careful to that.
It's the same party.
Now let's be clear. When a court in Abuja issues an order, especially when it's an interim order, that's an ex parte order that is represented based on representations made to it by a council, and it turns out that the court made that order believing the council, and whatever the facts that they believed in were ultimately, were turned out to be wrong, or to not have happened, or to be incorrect, or to be outright lies. That becomes the problem with the council, not the judge, not the court.
Yeah.
So the court has made an order, it's an order. So what happens now when there are conflicting orders? One thing that is important is that parties who approach the court, especially lawyers, must possess some sense of good faith. Lawyers must possess also a minimum understanding of the legal process. The point is that it should not be hard to understand that it is the responsibility of the Chief Judge of Benue State to give directives as to the operations and management of the Benue State Local Government Election Tribunal.
Before I let you go, you've raised the issue that I wanted to raise. Someone said, the people who are causing these problems, call it problems, are lawyers like you, because the judge can only deal with what he has right before him, and that the onus is on the petitioners or complainants to make sure that every information, even if he's going to lose his case, is made available even to the defendant or complainant and to the judge.
When you say lawyers are the problem, you may not be far from the reality, which is the truth. However, there are a lot of factors. The factors are that. Okay, so people forget, and especially lawyers must understand that they are mere ministers of in the temple of justice. They are meant to assist the court to reach justice, and they have an obligation either by the rules of professional conduct or by express provisions of the Legal Practitioners Act to ensure that at every material time, whatever depositions that they present to the court, to the best of their knowledge, must first of all be the truth, and then they also at every time present to the court the true situation, the true state of the law. However, there are expedient situations lawyers are faced with. A lot of pressure from clients who come and impose a lot of things, and a lawyer needs to balance such high ethical standards with the need to also make money as a businessman. So in trying to also do the bidding of your client, collect money, and then balance it with the ethical standard of being a lawyer and ensuring that truth is to be told to the court has always been a very difficult quandary balance for the lawyer. However, please, we must strive to first of all at every time, because where you have institutions that don't have alternatives like the judiciary, all hands must be on deck to ensure that we educate the public that please, however wrong a decision that proceeds out of a court, we must continually hold the court with such sacrosanctity that we should respect its orders. Even if the orders were made wrongly, that's why we have provisions for appellate process. Go and then correct it, rather than appeal to force. This idea of threats, and then if you have any opinion on any matter, please do not be prejudicial. Do not judge it before it gets to the court. Let the court decide that, the courts have made orders wrongly and they acknowledge it, and they actually reprimand such lawyers and oftentimes recommend that they should be disciplined. This is a normal process and should not be taken out of the ordinary.
I wish we had time, Frank Tietie. I was going to talk about who reprimands the lawyers.
Oh, a whole lot. The lawyers are always suspended, they're punished, licenses are seized and all that. I think
we don't have that.
We'll
leave it there. All right, that was Frank Tietie, Arise News analyst on the case in Benue State.